Kinder Morgan is a company that owns extensive energy infrastructure specializing in pipelines and terminals. In 2013, Kinder Morgan applied to the National Energy Board of Canada in regards to installing a second pipeline parallel to an existing one stretching from Alberta to British Columbia. This proposed expansion by Kinder Morgan was met by protests by various Indigenous groups, government officials, and non-Aboriginal communities. On May 29th, 2018, the federal government purchased a pipeline from Kinder Morgan for $4.5 billion. The federal government's plan to go ahead with the pipeline expansion was stopped dead in its tracks August 30th, 2018, when the Federal Court of Appeals quashed its approval. This ruling was due to the federal government's failure in the duty to consult with the Indigenous communities. The National Energy Board report on the environmental impact of the pipeline imposed was also found to be lacking in adequate assessments. The main concern is voiced by the Indigenous groups who see this increased output as dangerous in regards to the marine life and fresh water surrounding the communities. First, we must look at the land the pipeline crosses over and who is being impacted by the historic context. In Alberta and British Columbia, a major point of interaction between the Indigenous peoples and the government was through the creation of treaties. Treaties are formally concluded and ratified agreement between two parties. The proposed pipeline route runs through two major treaty territories. They are both numbered treaties. These treaties continue to govern the region since their signing in the 19th century. But the landscape has changed a great deal. The main motivation for the government in regards to signing these treaties was to partition the land for non-Aboriginal settlers. The first of these two agreements was Treaty 6, signed on August 23rd, 28th, and September 9th of 1876, and the second agreement was Treaty 8, signed on June 21st, 1899, between Queen Victoria and the First Nations of Lesser Slave Lake. The Kinder Morgan Pipeline Expansion Project hopes to cross these territories with the cooperation of the Indigenous communities in these areas. The historical context of Treaties 6 and 8 impact how Kinder Morgan and later the federal government proposed to expand the project. Indigenous communities' abilities to govern their traditional lands has been clearly defined through the treaties. This historical context of the region is also impacted by the different interpretations of the language used in the constitutional process. This has had a point of miscommunication between Aboriginal groups and the Canadian government through the decades. This ties back to the August 30th, 2018 ruling that found the duty to consult with the First Nations communities had not been adequately executed. This ruling by the Federal Court of Appeals overturned the pipeline expansion construction. The duty to consult is not law, but it must be honored by the Canadian government to the full extent. The Kinder Morgan pipeline has run into legal issues that have bogged down the construction of the project, eventually leading to the sale of the project to the federal government under Justin Trudeau. The National Energy Board Act 1985 outlines the necessary precautions and regulations that must be followed by pipeline projects in Canada. The risk of oil spills is governed by Section 48.12(1), stating, if the unintended or uncontrolled release from a pipeline of oil, gas, or any other commodity occurs, all persons whose fault or negligence the release is attributable. At the point, Crown immunity comes into play. It is a legal doctrine which states that the government cannot commit a legal wrong. Although the scope of Crown immunity has been lessened by statute law in recent decades, the main point of contact between Aboriginal communities and the federal government in the Kinder Morgan pipeline expansion has been through the duty to consult. This duty arises when the Crown contemplates decisions that would affect the treaty rights of the communities. There are constitutional and legal issues in regards to the Trans Mountain Pipeline project as well. On May 24th, 2018, a pair of legal challenges to the provincial environmental certification of the extension project filed in British Columbia failed to overturn the granted certificate at the BC Supreme Court. At the Federal Court of Appeals, the applicants applied to judicially review the board's decision to approve the planned route and construction methods employed by Kinder Morgan. Among the issues raised at the Federal Court of Appeals against the National Energy Board was the weighing of evidence and the reasonableness of findings and determinations. In British Columbia, Court of Appeals, April 26, 2018, submitted a constitutional reference question regarding the provisional autonomy over environmental and legal and economic impacts of pipelines. The Kinder Morgan pipeline has no shortage of constitutional and legal issues which, in the words of Alberta Premier Rachel Notley, could come to a constitutional crisis. There are a number of legal arguments for and against the pipeline that can be made based on the facts in regards to the failure of the National Energy Board, which started in December of 2017. The National Energy Board allowed Kinder Morgan to bypass two bylaws from the City of Burnaby, British Columbia, which were put in place specifically to defend against environmental degradation. On August 30th, the Court of Appeals decision questioned the scope of environmental assessments by the National Energy Board and the role they played in the decision. Aboriginal governance must also be considered as the Kinder Morgan pipeline illuminates the sovereignty Aboriginal people have over their land that is affected by the expansion project. The United Nations Declaration of the Rights of Indigenous Peoples, Article 3 states, Indigenous peoples have the right to self-determination, allowing communities impacted by the pipeline to choose the best pathway for their community, either in support or opposition of the project. Aboriginal peoples have provided with clarity a defined and although contended treaty right. Aboriginal sovereignty is recognized by Treaties 6 and 8 as they possess the inherent right to self-determination to either accept or fight the pipeline expansion passing through their territories. Treaty 6 outlines the provisions of the federal government, which include a medicine chest, protection from famine, and on-reserve education, but since assigning the community's needs have evolved. There's also been elements of miscommunication over the treaty terms by both the Indigenous communities and the federal government. Treaties 6 and 8 were understood by the First Nations peoples to be a nation-to-nation agreement, but over time the European view of subjugation dictated its discourse. The mistreatment of the Indian under the Indian Act 1876 has also had relevance to the Kinder Morgan pipeline construction, as the restrictions imposed by the Act have shaped the communities affected by the pipeline today. In the historic context, the land has held deep meaning for Aboriginal communities as well. If a pipeline is to be constructed along the existing route, there are certain legacies and traditions that should be honored. The land was used as a sustenance, providing Aboriginal peoples with what they absolutely need in pre-contact times. With the arrival of Europeans, the gift-giving economy became less reliant on the landscape, and more people came to depend on European capitalism, which transformed the land. In modern times, the land is being partitioned into reserves, and the land is now viewed through the European lens of property. Spiritually, the land is a living museum of communities. A pipeline expansion would have to honor the regions sacred to Indigenous peoples, perhaps even finding an alternative route. Most spiritually significant lands can be secured by communities through grant of a title, allowing for direct Indigenous control of the region. A variety of First Nations people have a relationship to the land that the proposed pipeline by Kinder Morgan would cross. In particular, there is one primary group who is against the current pipeline expansion, the Lower Mainland Squamish. This community boasts a vibrant, temperate, old-growth rainforest and is committed to restoring environmental and culturally active people within their groups. In contrast, Alberta's Chipewyan First Nations support the pipeline expansion project. The advocate for the construction of the pipeline with Aboriginal ownership, stakes, and economic development on their land. The First Nations' relationship to the land are diverse and impact a number of communities who have had reasons to support or oppose the project. Indigenous communities most impacted by the controversial pipeline are those who come in direct contact with it. As of July 5, 2018, Kinder Morgan claimed to have signed agreements with every First Nations lands who the pipeline directly crossed. Although they did not disclose which communities these are, it is evident that Kinder Morgan was yet to sign agreements with every Aboriginal community whose traditional territory would be crossed by the pipeline. This is where the Royal Proclamation of 1763 comes into play. This document recognized that the Indigenous title could not be extinguished through the treaties with the Crown. Section 35 of the Canadian Charter of Rights and Freedoms also recognizes Aboriginal title, but it does not define what the title is, resulting in uncertainty over the rights they can evoke. in relation to the pipeline expansion project. In particular, 4 First Nation groups along the planned route have signed an agreement with the pipeline expansion. As of November 17, 2018, the debate of whether or not the pipeline will successfully be completed and approved is still in question.